Hi, good evening, everyone. Thanks for joining us. I know folks are still getting admitted to the room, so I'll sort of kick off in just a minute as people are coming in here. We've got a great agenda this evening, so we'll go over that momentarily. And I'll go ahead and get started right now. I know folks will continue to join us, but my name is Jenny Mattingly. I'm the Vice President for our Public Policy and Stakeholder Engagement team here at the Partnership for Public Service. And I'm really thrilled to be doing this tonight because I know it's been a moment since we've done one of these town halls, and there's a lot of questions and issues to cover that are going on right now. And we have our partners and friends here from Rise Up Legal Network and Civil Service Strong, and we'll do an introduction in just a minute. For those of you not familiar with the partnership, we're a nonpartisan nonprofit working to build a better government and stronger democracy, and we do that through a whole variety of things like these FedSupport webinars, building resources, leadership development, advocacy, and really working across organizations and sectors on what good government looks like. You'll hear more from our partners today about the work they're doing also and all the things we're focused on this year. But I do want to share just a couple housekeeping notes before we dig into the conversation. Throughout the webinar, for our listeners, please feel free to submit a question in the Q&A function. We'll do our best to answer what we can get to. And given the complexity and nuances of topics we discuss, we may not be able to address every question or specific instance and circumstance that comes up, but we'll continue to hold these FedSupport webinars on a regular basis to dig into other topics that you raise. And if you miss a talking point or want to revisit this webinar, that's most relevant to you, this conversation will be posted along with all our past webinars on the FedSupport Hub YouTube channel. I imagine our partners will have it as well. So you'll be able to find it after this or share it with colleagues and friends. And with that, let's get started. And I'd like to give our friends on the screen here a moment to introduce themselves and tell us just your name and where you are. I know people have probably seen you all for a moment, but why don't Jeff and Suzanne, I'll turn to you, and then Rob and Mike, and then we'll get into the meat of our discussion.
I'm Jeff Nesbitt. I'm the Acting Executive Director of Rise Up Federal Workers Legal Defense Network.
And I'm Suzanne Summerlin. I know how to unmute myself, and I'm the General Counsel of the Rise Up Federal Workers Legal Defense Network.
Hey, everybody. Excuse me. Hey, everybody. Rob Shriver, the Managing Director of Civil Service Strong at Democracy Forward.
And I am Mike Martinez, the Managing Counsel at Civil Service Strong.
Great. Thank you all for being here this evening. And I think a lot of folks have probably seen us on some of these webinars and town halls before talking about issues, and would love to start by giving folks an overview. We're just for people listening, we're going to talk a little bit about what the landscape looks like now in terms of what we've seen over the past year impacting both current and former federal employees. And then we'll pivot a little bit more to talking about what we all see coming down the pipeline or what we're focused on and what resources are out there. So I think we'll give a kickoff right now to Mike. I think you were going to, or Rob, you were going to give us a quick overview of the landscape and get us started.
Yeah, Jenny, I just wanted to cover a few general things up front, and then Mike and Suzanne can get into some more specifics around the cases. But I think it's important for folks to understand that the legal program that we're all involved in against the Trump administration is yielding some very positive results. Sometimes it might not feel like that because you hear about the Supreme Court or you hear about particular cases and different rulings coming down, but just to give you a sense of how things are going. So first of all, the Trump-Vance administration has faced more than 600 lawsuits from people and communities across the nation, and they are losing in court more than 70% of the time. And they are facing losses in front of courts with judges that are appointed by Republican presidents, Democratic presidents, and even President Trump himself. And with all that you hear about the Supreme Court, it's important to keep in mind that less than 5% of these cases are actually going to the Supreme Court. In the civil service space, the administration has faced major setbacks, including, for example, with respect to the mass termination of probationary employees, all the way up through their efforts during the government shutdown to try to leverage that to carry out far-reaching reductions in force. Major Trump policies are getting blocked. The cases are leading to the uncovering of critical information. You may have heard about the recent revelation in a case brought by Democracy Forward that Doge had impermissibly shared Social Security data with an outside voting advocacy organization. So it's important that that information come up and be made public when we get it through lawsuits. And also, sometimes the administration is flat out abandoning some of its initiatives because of our litigation. Recently, they abandoned an appeal of a case involving the anti-DEI Dear Colleague letter that was set out by the Education Department. So, a year into the administration, I wanted to just like underscore the statistics, those data, to reemphasize that this fight is worth it. It's sadly not ending anytime soon. And many of us are working together to fight as hard and as fast as we can to respond to what's coming out of the administration. And it's really important that we keep it up. So I was going to turn it from here over to Civil Service Strong Managing Counsel Mike Martinez to go through some of the cases that are of particular interest to civil servants. Mike?
Thanks, Rob. I appreciate it. So just to kind of set the table, about a year ago, we had some idea about what the administration would do. We had Project 2025. We had heard them on a campaign trail for a while. So we knew the civil service was in the crosshairs, but didn't quite know exactly how they would do it. So as we've seen over the past year, some of that has happened. Schedule F has turned into Schedule Policy Career, for example. But there have been a variety of other policies that we've had to challenge in court. And they're coming from many different angles. And so today I'm going to take some time to walk through a few of them. And I believe you have a slide that might kind of help just so folks can follow along here. Just sort of kind of an overview. The biggest argument that the administration is trying out is its Article 2 powers under the Constitution. So the Constitution gives the president a lot of power over the civil service, but no president has ever used it in this way. They're making the most maximalist arguments about their ability to fire whoever they want for whatever reason they want. So that's kind of underpinning a lot of these cases. So I'll take these in turn, and later on we'll have some time for Q&A. But these are all kind of looking back, and some of these will continue, but later on we'll talk about some kind of around the bend type threats. So first, rifts and reorganizations. I'm sure you all have seen this. Lots of news about agencies trying to cull their workforces in ways that are completely improper. So rifts are a valid tool for agencies to address their workforce, funding issues, policies they'd like to change, but they're really meant to target positions. And what we've seen is the administration target individuals they don't like, for example. Statutory functions that are required by Congress that they don't want to do, they'll just cut the workforce and say that that's a valid use of that power, and it's not. So we have probably our biggest RIF cases out in California. It involves the executive order that mandated that agencies RIF employees. We've been fighting that alongside partners from the unions and a law firm, Schriver, for quite a few months, and there's been a lot of good progress there. But there are many other RIF cases across the country. The shutdown RIF case that stemmed from the administration wanting to fire employees during the last shutdown was one that we're involved in. It's still going on. That's relevant because in a few days we may be facing another situation like that where there's another shutdown, and we have not yet seen what the administration is planning there. There are also very agency-specific RIFs that you all may have experienced or may have been a part of. USAID, Department of Education, CFPB, you name an agency and likely there is a RIF, maybe not from an entire office, but there's certain spot spots where there's impact everywhere. So that's the RIF and reorganization bucket, and we can go into that a bit more later. And then the hiring and firing. I talked about schedule, policy, career. In the first Trump administration, we heard of Schedule F, and it's basically the same idea that the administration would put anyone with any sort of policy role into a new category. And by putting them into this category, they would strip them of any sort of rights they have accrued. We've long thought that that was unlawful. When I was at OPM as a deputy general counsel, we worked hard on regulation that would try to block that. And now we have an executive order that has created the schedule, but there's now a regulation that's going to happen over the next few weeks or months. And then once that happens, the litigation will kick back up again. So that is going to be a bad result for the civil service. We're also seeing OPM's merit hiring plan. So not just on the firing side, but also on the hiring. There is a question that you may have seen that asks applicants what their favorite executive order is and how they would go about implementing that executive order from the president. That's just an improper question to ask applicants. It has no bearing on their ability to perform their duties. It just basically wants to cull out certain employees who are aligned with this administration. So there's a litigation there too, and the District of Massachusetts that has a preliminary injunction hearing in about a month. So that's ongoing and developing in real time. The removal powers of the president, as I mentioned before, are really at the center of all this. The Supreme Court will likely hear cases about the president's Article 2 power, maybe not this year, but maybe next year. You're seeing this argument everywhere. You're seeing it in the removal of specific individuals who are high profile that you've seen maybe in the news. And you're also seeing it with lower level employees that the president or folks on Twitter don't like. We're seeing influencers on the right identify certain employees, and then a few days later they're terminated, and all it says on their paperwork is Article 2, and no reason given except the president's power. We've fought that at the MSPB, which you'll hear about in a bit. We're fighting that in federal court, but that ultimately is a big question that will maybe determine all of the other rights if that were to prevail. So I hope that the Supreme Court realizes the gravity of that argument and that there is a tailored result, but that is something to look out for. Constitutional questions I have on here because it's really kind of on the forefront of these arguments. We've now dealt with RIFs, we've dealt with schedule, policy, career, at least the beginning of it. But now there are more complicated questions about the First Amendment, for example. Can an employee go out in public and speak their mind about their work and what's happening in their space without being fired? We're seeing those terminations all over the place. So courts will have to decide, where those lines are. We saw a few months ago, EPA employees, for example, sign on to a letter criticizing the work that the agency was doing, and they were fired. There's lawsuits about that, and I think HHS has a similar fact pattern with a letter that had signed on by employees. So those questions about the First Amendment will be big, are currently big, and will be big going forward. And also questions about the Fifth Amendment. The Fifth Amendment says you have a property interest in your continuing employment if you've met certain criteria. You've been at your position for more than 1 or 2 years, depending on your position, or you have current continuous service that to qualify you for this property right. So whether that can be taken away from you under Article 2 or any other theory is something that the courts will have to grapple with. Mixed cases are a category of cases that are kind of combine the MSPB and EEOC processes with federal court. If you have a termination that's based on a RIF or any other reason, but you also have a claim of discrimination, say you were targeted for your age or a couple other protected factors, you can bring that claim as part of your EEOC or MSPB action, and then after a certain amount of days, usually 120 days, you can take that case to federal court. So we've seen those cases, for example, in the DEI space, where individuals brought cases at the MSPB. After 120 days, they were able to bring those cases to federal court. And that has a big benefit in that you get out of the kind of the morass and the slog of MSPB practice, and you can take your arguments to federal district court, where you have a lot faster timelines. APA cases, these are cases under the Administrative Procedure Act, which is an act that allows you to challenge final agency action for being arbitrary or capricious or contrary to law. And we have seen these cases, we're actually involved in some where we're challenging specific agency action. So for example, the Office of Special Counsel, which was a body that is supposed to handle prohibited personnel practices, put out a directive a few months back that really changed the way that they investigate probationary employee terminations. So because that's a final agency action, it's a directive, you can actually challenge it under the APA. And Democracy Forward has brought a lawsuit challenging that directive under the APA. And there's a variety of other examples like that where there are challenges in federal court that that touch on whether the reasoning of the action or the process was appropriate. And the last item I have on here is MSPB channeling. So that's a kind of in the weeds for folks who are not familiar with the civil service laws. So if you want to bring a case, and if you're an employee, those cases go to the MSPB, and that means your case is channeled. If you try to bring it in federal court, back to the MSPB. But that's really not in statute. It's been part of the practice for decades now, and it's really on the basis of having a forum at the MSPB that's going to be appropriate to hear those claims. And we're starting to see courts pick at that, whether the MSPB is actually functioning as intended, whether it is an appropriate forum, whether it's captured by the administration or not. You're seeing that at the Fourth Circuit, for example. You're seeing it in briefings and in a variety of different circumstances. So we're going to keep a close eye on that, because that is going to be a big development. If the courts decide the channel is actually broken, that means that employees who have been terminated can opt to, instead of going to the MSPB, to go right to federal district court with their claims. And that would be a helpful development. And so I know that's a lot of information. I'm happy to take questions later on when we have that. I know there are already some in the Q&A box, but I will hand it over to Suzanne unless Jenny or Rob have any other thoughts.
All good. Thanks, Mike. Suzanne, why don't you jump in? And I know, as Mike said, there are questions there where we will get to those, and they fit in with the others. And for the one question in there, this session is being recorded. So yes, we will have that link up later. But Suzanne, over to you.
Great. Thanks, Jenny. And thank you, Michael. My overview is going to focus on these three topics, starting with collective bargaining and the landscape for unions. As most people are aware, in early 2025, the administration issued an executive order that ultimately stripped collective bargaining rates from about 85% of the unionized federal workforce. So 85% of the people who had a union on this day last year are not being allowed to exercise their union rights today. In real numbers, that's about 1 million workers. There has been litigation on this topic, and we've covered it extensively in other forums, and we write about it at Rise Up. We have a litigation tracker that you can use. So, we always have something up there about like what's going on and the latest. And there have been wins. There's been, preliminary injunctions that sort of come and go. But broadly right now, most people are not having their unions recognized. Most agencies continue to refuse to recognize unions or honor collective bargaining agreements. And this stems even to things that happened prior to the executive order being issued. So, and I'll talk about that when we talk about arbitration. TSA announced in late December that it's attempting to rescind its 2024 CBA and unilaterally implement a new framework that is affecting about 47,000 employees right now. The U.S. Agency for Global Media got an injunction, so they have a very specific injunction that just preserves their CBA and their union recognition for this time. So it's really hit or miss out there. The practical reality is, even when, unions technically retain recognition, agencies are still not fully recognizing union rights. They're still refusing to bargain, declining to process grievances, declining to participate in the grievance arbitration process, and essentially just treating CBAs as if they're voided. There also are, because of the rifts and reorgs that Michael touched on, massive changes to different bargaining units. So, when the administration used national security designations to reorganize and alter who is covered by union contracts, it essentially shuffled around a lot of what we call like unit certifications. And so, these legal issues called accretion and succession pop up. And basically, folks who may have been in one bargaining unit last year have now been transferred to another bargaining unit, and then there are questions over like which contract applies to them. So there's a lot legal battles sort of brewing in this area, as well as agencies are reorganizing, merging functions, and relocating work. um, there was a DC Circuit heard oral argument in December on cases involving NTU and AFSA and FEA challenging some reclassifications that are happening. um, we do not have a ruling on that yet. So we have a few rulings, I think, in the hopper that we're waiting on. They're out of the Ninth Circuit, and this is another one here in the DC Circuit that I think we are definitely keeping an eye on in terms of in the union space and seeing if union rights are going to be respected. Well, while not everybody can make it to federal court, there's this issue of challenging going or channeling going on that Michael touched on. Um, the agency that the government is saying to federal judges that unions need to go to first before they come to federal court is the FLRA, the Federal Labor Relations Authority. Um, it is, however, as Michael alluded to, not really functioning as an adjudicatory body right now for labor disputes. The vast majority of cases are being held in abeyance, meaning that they're putting a pause on deciding any cases right now, because of the litigation going on over these executive orders. And that sort of creates this catch-22 situation where the government is arguing that unions have to go to the FLRA, but the FLRA isn't really functioning as it should. They do have a quorum, though. In December 2025, so just a month ago, they confirmed Charles Arrington to the FLRA for a term that will run through July 30th, 2030. And so they will have the ability to issue decisions, at least for a while, but they're just sort of choosing not to, I guess, at this point. And the practical application means that unions really can't obtain timely relief. And so that does sort of force more of this litigation into federal court. Another thing that we're sort of eyeing right now is the folks at FMCS, the Federal Mediation and Conciliation Services. It's a very important, small but mighty organization that is currently facing its third shutdown in one calendar year, because they are in the omnibus or the minibus funding that is still up in the air right now. So they don't have their funding situated. So FMCS is preparing to not be functional again soon. They've been off and on all year for various different reasons. So that is another thing that we are like sort of watching, because FMCS is incredibly important, not just to federal labor workforce, but to all of labor, because the FMCS assists in helping solve labor disputes in every single type of industry across the country. Major League Baseball, nurses, teachers, you name it. So that is an incredibly important organization, and it is once again on the precipice of not being functional for the third time this year, or in a year. At arbitration, however, there is still hope, and there are still good things happening. So a lot of arbitrations that had been filed prior to when the agencies, what we call repudiated the CBAs, basically ripped up the contracts and says you're not a union anymore. There was stuff that happened before that we still have to litigate. It's just because you rip up a contract on, August 1st doesn't mean all the stuff you did leading up to August 1st you can't, have a right of action to. And so that's basically what the unions are arguing, and they're winning. We have gotten some recent wins. Just this week, an arbitrator ordered HHS to rescind its return to office directive and immediately reinstate telework and remote work agreements for the NTEU represented employees. Also recently, we had a separate arbitrator found that the Centers for Medicare and Medicaid Services violated its statutory obligation to bargain with AFGE over implementation of the return to office directive. Similarly, another AFGE case involving the EPA. an arbitrator found the EPA violated the contract by failing to negotiate with AFGE Council 238 over the return to office policy changes. And finally, just today, just today, we learned about a case involving NAIL, which was the National Association of Independent Labor, labor, which is every day I learn about a new federal sector union. I love it. But arbitrator Marvin Hill ruled that that the anti-union EOs violate the hierarchy of law and can't strip him of jurisdiction over the grievances. So this is all great, right? The unions are winning at arbitration. Arbitrators are hearing these cases. We love to see it. But there's an enforcement problem. Because the unions are not recognized by the government, they say we don't have to follow this arbitrator's order. Arbitrators, they don't have a U.S. Marshal Service that go out and help them, make sure that their orders are being followed. They write them and they say, okay, follow them, but then that's sort of as far as they can go with it. And under the federal service, if you are receiving an arbitration award, it is not a final and binding award that's enforceable until 30 days after it's issued, so long as the non-prevailing party doesn't file an appeal. We call them exceptions. And that's what the government's doing in this case. They're filing exceptions to all of these arbitration decisions. To the FLRA, which I just mentioned to you, is not hearing any of these cases, right? So this is essentially creating an indefinite hold on all of these victories, which is really, really tough because the arbitrator has found, unquestionably that the agency has broken the law here, that the union and its members are entitled to relief, and yet it is going to stay frozen in ice, like so many of our cars outside, until the FLRA decides to hear these cases and get them moving again. So that is sort of the situation right now with collective bargaining in the union landscape. Tough out there, but like we know spring will come. There are rays of hope, right? Like there are things happening that we know are really good things that when they are enforced in the future will be great. But at the current moment, things are tough. Similarly, at the MSPB, we do have a restoration of quorum. They have a functioning quorum for the first time since April of last year. We have James Woodruff II, who was sworn in as a board member in late November. His term runs until March 2032. So the board can now issue final decisions, which is pretty critical for employees who've been waiting for resolution of their appeals. But at the same time, the MSPB is also feeling its own sort of operational constraints. The administration has closed the New York field office permanently and redirected all of those cases to the Washington field office. And so that is creating a huge backlog of cases. And today, we learned about a bunch of these cases today at the Rise Up Volunteer Lawyer Corps meeting, which we do have recorded. So if you're one of our volunteer attorneys, you got that training video today in your email. And if you're not, maybe consider joining us. But we talked about how there are multiple class action appeals pending at the MSPB, and also this idea of consolidated cases at the MSPB. A lot of folks who have filed pro se, which means without an attorney on their own, at the MSPB are receiving these what we call acknowledgement orders. And they basically say, hey, your case is probably going to be consolidated with a whole bunch of other people's cases. So stay tuned. It's really interesting because this is something that the MSPB has not really done in the past. But what we're dealing with here, because the scale of the adverse actions in 2025, like 317,000 federal employees have left, at least, it creates this potential for aggregation of appeals that the MSPB has never seen. They're not designed to handle this. This organization was designed to handle like one-off cases or maybe small groups, but not like massive reorganizations of the federal workforce. So they don't really have great fleshed out rules for dealing with these situations. If you're a pro se litigant at the MSPB and you feel like maybe they're kind of making this step up on the fly, you're not alone. We're hearing from attorneys who practice in this space who are experts who also feel like this is all just like we're playing jazz with it. So that's sort of like the situation there too. A lot of unprecedented stuff. And a lot of, I think the administrative judges are doing their best with limited resources to move these cases through as efficiently as they possibly can, but also understanding that like this is a Herculean task to get everybody through. So they're winding their way through, and it will take some time. But I would suspect, and I think the general consensus is perhaps towards the fall or the winter of 2026, we will start getting some early decisions on these cases involving the probationary appeals and things of that nature. So we'll definitely, I'm sure, be updating you guys as that happens throughout the summer and into the fall and next winter. Also, at the MSPB, the administration, as Michael was mentioning, continues to press constitutional arguments that the structure of the MSPB violates Article 2. You know, they're basically saying that the tenure protections for the members unconstitutionally limit presidential control over the executive branch. It sort of parallels the Schedule F litigation. Both of them are resting on this theory. It seems that career employee protections are, unconstitutional overcorrections, that we can't have a professional apolitical civil service, that somehow that's unconstitutional. If successful, this would fundamentally alter the MSPB's independence and ability to provide meaningful review. So oral arguments for that case, I think, are coming up in February. And so we will absolutely be looking and keeping an eye on that as well. And yeah, that's it. I think those are all my updates for these 3 bullet points. But for, in terms of questions and stuff, happy to answer those when the time's right.
Yeah, thank you, Suzanne. That's a lot. And we popped into the chat, the litigation tracker from Rise Up, because for folks who want to dig more into the weeds on some of the cases that both you and Mike mentioned, I know that's in there. And we do have a lot of questions about things coming down the pipeline here that people can expect. But in terms of legal questions, maybe this is the right moment to pause. And in a minute, Rob, I want to get to some of the other non-legal issues that we've seen. But Jeff, would it be okay to ask you to jump in for a moment? Because we are getting questions about legal support and people who have questions. It would be great to talk about Rise Up a little bit and clinics.
Okay, I'd be delighted to, Jenny. First of all, let me say that all of us at Rise Up hope that the day will come when the services that we provide are no longer needed by federal workers. But until that day does come, Rise Up will be here for federal workers, current and former. What does that mean? We provide a range of services for federal workers. One of the most significant is that we offer free up to 1 hour legal consultations with our volunteer lawyers to educate federal workers so they understand their legal situation and their options going forward. This is generally provided through our Zoom virtual legal clinics. To obtain a consultation, you simply have to go to our website, workerslegaldefense.org, which I think has been shared in the chat several times, and click on where it says federal workers at the top of the page. Then fill out the short form. We hold several legal clinics each month where we conduct these free consultations. To qualify for a consultation, you'll have a brief interview with one of our volunteers, either beforehand or at the clinic, where we need to establish that you have a federal employment question and that you're not already represented by an attorney. When you respond to an invitation for a clinic, you will receive a link to a Zoom meeting where when you enter, you'll be placed in a breakout room with one of our volunteer lawyers. That's how we provide these consultations for the most part. At our clinics, we also have expert federal labor sector lawyers. So if your volunteer lawyer has a question about how to respond to you or analyze the situation, they say, I'll be back in a minute or 2 or maybe 5, and they go talk to one of our expert lawyers, they get their answer, and they come back and help you analyze your situation. Even if you've already had a consultation, if you have a new issue that you need help with, come back to our website and sign up again. We also offer a variety of other kinds of assistance to federal workers. There's been some mention of our litigation tracker. To see our litigation tracker, just go to our website and click on the button on the top that says litigation tracker. When you at our website, you'll also see an item that says resources. If you click on that resource item, what you'll see is about a dozen or so documents that will give you information about various legal issues, how to proceed at MSPB, how to deal with having taken the fork in the road, deferred resignation, all kinds of other issues that might come up that you will find useful. And finally, Suzanne, our general counsel, does a marvelous job in preparing news updates every week. She calls it the Solidarity Docket. If you click on the news tab at the top of our webpage, you'll get to the Solidarity Docket. We also participate in a variety of events like this one, and we'll continue to be hosting and or participating in these events. We at Rise Up know that the administration's unprecedented attack on the federal workforce is doing immense harm, both to individual workers and the ability of the federal government to function. We will be here to support federal workers as long as the need continues. Let me finish with this thought. Thanks to all federal workers for your valuable and underappreciated services, and Rise Up stands with you and seeks to assist you to the extent we can. Thank you.
Jeff, thank you for that. I think one of the things, the takeaways, right, and that Rise Up does, and we hear people ask all the time, how can I get legal help on things? The clinics are a great way because they're sort of a just-in-time thing where people, and you can get it throughout the process of wherever you stand in your process of, lawsuit, considering a lawsuit, some sort of action, and it's pro bono. So I do think, and it's a lot of our organizations I know support the work you all do. So encourage folks to ask questions, reach out if they need help. So thank you for that.
Let me add just one thing. Well, we can't provide the kind of representation of taking people's case to court like I wish we could. Just giving people who are in uncertain situations certainty about what their situation is and what their options are is something we've been told over and over again by workers that they really appreciate.
Well, there's so much that's uncertain right now in this time that anything that answers questions and provides some measure of certainty is helpful. So with that, speaking of questions and uncertainty, we've got a lot in the chat, and they're somewhat forward-looking. But Rob, I think as you cover some of the other issues out there that we've seen over the past year, they're also ongoing that we'll see going forward. I know people are really still waiting for their retirement benefits. People are thinking about reasonable accommodations. People are wondering about scheduled PC. And so could you talk about some of the, and I'm sure we all have things to add to this, but other challenges that that are out there that we've been following over the past year?
Yeah, sure, Jenny. So the processing of federal employee annuitants and their retirements is an issue that's near and dear to my heart, given my time at OPM. And in the best of times, it's been a challenging process because it still is paper-based, and that can take a while. I was really proud of the work that we did when I was at OPM to start a more broad-based automated process and to really bring down the wait times and bring the backlogs down substantially. They have exploded, and it's not a surprise because the way that the retirement process works is there is activities that the agency has to do, that the retiree has to do, the agency has to do, and OPM has to do. And when you launch a mass deferred resignation program and encourage as many people as possible to take it without really regard to the jobs that they were doing, you wind up losing capacity of the very kinds of people that need to process retirement at the same time where you're driving people into retirement at numbers that we haven't seen perhaps ever in the federal government, or at least since the 1990s with reinventing government. So they've created a big problem for themselves, and they've created a customer service challenge. One of the ways to deal with that unfortunately, is to go through your member services, your congressional member services. They have constituent service offices who exist to help you with challenges that you're having with the federal agency. And so if you are caught in a black hole with your retirement, I would suggest you reach out to your member of Congress and insist that they inquire of OPM what the status is and get you information. That can be an effective way to handle that. There are several questions in the chat about Schedule F, Schedule Policy Career. For those who may not be intimately familiar with all of the details of that, Schedule Policy Career is this administration's version of part of Schedule F that it had attempted to implement at the end of the first Trump administration. And it deals with the performance management side of things. They have also announced special hiring rules like the Schedule F hiring rules that they tried to do before, but they've broken that out into something that's a new Schedule G. But that's further behind the Schedule Policy Career regulation on the performance management piece. So let me just say that OPM continues to move forward with implementing the Schedule Policy Career rule. They had issued a proposed regulation on this. They got over 40,000 comments on their proposed regulation. There's been some analysis that 90% of those comments or more opposed the use of Schedule Policy Career. So they have their work cut out in order to justify the position that they've taken in that regulation, especially because OPM in 2024 issued another regulation that reinforced that Schedule F was really at odds with the long-standing history, policy, and the law on civil service protections for federal workers. That regulation generated over 4,000 comments, which was a lot for an OPM regulation, but not the 40,000 that this one got. And 67% of those comments were in favor of that OPM policy. So you had OPM go through a transparent regulatory process less than 2 years ago that generated enhanced civil service protections, or at least clarification of civil service protections, that 2/3 of commenters supported. And now you have OPM completely reversing course with a new regulation that seeks to strip tens of thousands, if not hundreds of thousands of federal workers of their civil service protections. And they've gotten 40,000 comments where 90% are against that. So we have been expecting that regulation to come out. We had expected it before the holidays. It has not yet come out. We expect that it will come out. We don't think that OPM is abandoning this policy. And when it does come out, you should be aware that there's already litigation that is in place that is sort of waiting to see what happens with the final regulation. And likely there will be new activity in that litigation when the regulation comes out. We will have other sessions like this when that regulation comes out to try to provide assistance to people who are notified that they are being moved into this new schedule. And again, Rise Up is available to you to bring those issues to them. And then just one more thing, Jenny, and before I'll turn the floor back to you, is we are also looking at how the administration is approaching hiring. Somebody in the chat has asked if we have any idea, ballpark, like the RIFs are going to continue, how far they're going to go with those. And we don't know, but what we do know is that there is a policy that for every one new hire they make, they have to let go 4 people. And there's some exceptions to that and whatnot. So, I think they still have a policy of shrinking the federal workforce, and that's based on headcount alone. But there is some hiring that's happening, and we're concerned about changes to the federal hiring process that we think are intended to introduce greater political influence over the hiring of career civil servants. So some of the things that they've done is they've changed the executive review boards that hire senior executives so that there now has to be more political SES than career SES. That's a complete reversal of policy. They've introduced 4 essay questions for applicants at jobs that are at the GS5 level and higher that include asking them about their favorite Trump executive order. I mentioned they've created this new Schedule G that's an exception to the competitive hiring rules and looks a whole lot like Schedule C hiring for political appointees. They've told agencies that they need to have hiring plans that are approved by political appointees. But in that guidance, they also gave broad leeway to agencies to do more hiring under Schedule C, which is pure political appointees, and Schedule G, which is, in my opinion, political appointee light. And now we've also seen them start to hire people for jobs that were previously performed by folks who were RIFed. And what agencies are supposed to do when they RIF somebody and then they have a need to fill that person's function, they're supposed to give that person a chance to come back into the job if they want to. And so we've got our eye on that, the policies both that happened in 25 and then how they're playing out in 26. And again, if you see irregularities in the hiring process that might affect you, if you were a RIFT employee, you can go to Rise Up and raise that issue there too.
Thank you, Rob. That's a lot of things that have been ongoing since last year, but also, a lot of things that we're watching for implementation this year. And I think that's the one thing that sticks out to me is that there were so many actions that happened in 2025 that we still haven't seen implemented yet. And so I think there's a lot of unknowns going into this year. And I know folks were also asking about, reorganizations. I think agencies still have reorganization plans out there. I think relocations could be on the table, depending. That's always a question. And then I also think there are, as you said, a lot more rules coming down the pipeline too. There are rules coming from OPM, I think, on suitability. There's a couple out there on probationary period appeals right now, on SES CDPs, candidate development programs. So I think there's just we're going to see a lot of issues play out. And I know agencies are working on the merit hiring plan where they're starting to build their staffing plans, these new sort of oversight boards to take, do the hiring and approve the hiring that you talked about. So I do think there's a lot of, for folks, unfortunately, I think there's a lot of questions still about what's coming down the pipeline. I did see one person, Rob and Mike, I'm curious, both of you, your perspective on this, asking about telework and reasonable accommodations and whether that's something, it's certainly a worry. And I think that is a question in my mind of how that's going to play out.
I will just say real quick, we have heard that agencies have been directed to take a fresh look at those arrangements. And with the expectation, I think that we have is that if agencies take a fresh look at those arrangements, they may change prior decisions about allowing 100% telework for people as a reasonable accommodation. I don't know if Mike or Suzanne even have heard anything more specific of that playing out.
The majority of what I've heard is that, telework is certainly in the crossfire. And so if your existing telework accommodation hasn't been rescinded yet, I do think that is probably the goal, like Rob was saying, in most places.
Yeah, so that's certainly, I think, all, the reality is a lot of these are still open questions for folks. Another question I saw in there that as we're talking about things that are still ongoing too are cuts to civil service benefits and salaries. That is more of a legislative, congressional issue. A lot of times, I think those conversations have been out there for years in Congress that I've been doing this. Right now, Congress is much more focused on the one thing we haven't talked about, which happens potentially in 2 days, which is a government shutdown, but it's a partial one. So, Mike, I don't know if you, Rob, want to talk about that, Mike, a little bit, because I think it is worth saying this is yet one more thing on the radar for folks.
I've heard the concern too. I haven't really seen any movement in that direction to cut any sort of salaries or benefits. I think I've actually seen the opposite. There have been some flexibilities with certain positions where certain IT and tech professionals, I think, there's a push to be able to pay them more. And I think that's kind of where some of the tech initiatives are going. So maybe some of the Schedule G positions could go in that direction. But we are keeping an eye on that in case it does happen.
Yeah, and I could just add, Jenny, to what Mike said and say that initially, as Congress was negotiating over the budget bills at the beginning of the administration, leading up to the end of the CR in March, if you can remember all the way back to then, there was a concern about a potential shutdown in March. We saw some language make it into bills that would have weakened federal employee retirement benefits, would have increased employee contributions, eliminated supplemental annuities. There was even language in there that essentially would have required feds to, I would say, buy civil service protections by agreeing to lesser retirement benefits. So in other words, if you were agree to be at will, then you could get a more generous retirement benefit. But if you wouldn't agree to that, they were going to cut your retirement benefits. So there was some initial noise around that. Many of us on this call work to educate Congress about problems with that approach, and there was a real effort to stop that from going through. That ultimately was successful. That those provisions were stripped out and didn't make it through the end of that negotiation. And Jenny, I don't know if you've heard. I have not heard those come back to life in connection either with the end of the shutdown after September 30th, the end of the 46-day longest shutdown in history, or in connection with the budget discussions right now.
Yeah, I haven't heard anything either. I think the budget discussions right now are really responding to a lot of other events going on across the country. And so I do think for folks on the, I'm sure folks have been following it, but just if you haven't, Congress has passed 6 of the 12 appropriations bills. 6 are still outstanding. The House has passed them. The Senate is considering them. Now those have gotten wrapped up in DHS, ICE, the Minnesota shootings. And so there is a chance right now that we're all watching is what happens when you have if Congress can't come to a deal on spending, there will be a partial government shutdown that does impact a large majority of agencies, DOD, DHS, I think HUD, and several others are in there. So that's just something we're all keeping an eye on. And unfortunately, I think government funding is going to continue to be an issue. I do want to pivot in thinking about what's coming down the pipeline. I do see a question in there about performance appraisals and what we've seen with things coming from the administration. I know for the SES, there were forced distribution of ratings where, only a certain percentage of senior executives could get ratings. I haven't seen any proposed rules recently on performance management, but I don't know if others have. Mike, have you tracked anything coming down the pipeline?
The distribution one was what I was going to mention, and just for some folks' their information, there was a long time rule barring that, and I think this rule gets rid of the bar. So that means that when SES individuals are assessed, they could be on a curve. So it's really trying to force more scale from 1 to 5, more 3s, 2s, and 1s. Right now, there's a lot of 4s and 5s out there, but they really want to kind of scale it in a different way.
I think actually something, this makes me think about, and I'd love to, as we get towards the end of this evening, talk a little bit about, we've talked a lot about the actions that are happening, but I know with Civil Service Strong, with Partnership for Public Service, with so many other organizations out there, we're both, helping folks navigate what's going on and also thinking about how you reform government going forward. So I'd love to give just a second to talk about those things before we pivot that to the folks on the line. We know there are so many more questions coming about regulations, legislation, actions that the government's taking. So towards the end of this town hall, we'll put out a survey of that you can answer online of what are the questions you still have, what resources do you still need. We know there are a lot of former feds out there who still need Fed support, career transition. So just letting folks know as I'm seeing questions in there that please reach out and let us know what you need. But Rob, would love to hear a little bit, because we are using this moment of extreme changes in the workforce and seeing some very negative things happen. How do we also think about what needs to happen going forward?
Yeah, thanks, Jenny. I think this, as terrible as this is, it is an opportunity to take a look at the way the government is organized, the rules that apply, and how those have affected federal workers' ability to deliver results for the American people. I have worked a lot with federal workers over my 30-year career. I was really honored to be a champion of federal workers as the acting director of OPM. And my view is that the people who are most frustrated by the federal bureaucracy are the federal workers themselves, because people come into government because they're mission driven and they want to make a difference. And then they have to figure out how to navigate the bureaucracy that's there. Many of those rules and processes there for good reasons, but they make it hard to get the job done. And so the fact that this administration is just kind of blowing through all of that gives us a chance to sort of take a step back and say, okay, we don't like what's happening. We don't like Doge. That's the wrong answer, clearly. But what might we be able to do to help federal workers be more empowered, to give them the tools that they need to make a bigger difference in the country and in their local communities, which is what they want to do. So we have launched a project called Democracy Works 250 that does just this. And I'm sure Jenny can talk about the Partnerships Project. We are working very closely together with the Partnership for Public Service, with other good government groups, with federal sector labor unions, and with organizations that never have really been engaged before in government reform initiatives, who are now seeing how hard it is and what an impact there is on their mission when the federal government's capacity has been gutted, and when the people that they relied on to do that job day to day in areas that they care about, like feeding people or protecting the environment or responding to emergencies, that they are now seeing the costs of not having federal workers there to do that, and they're coming to the table. And so we're taking a look at how can we reform the system and reimagine government so that we can generate better results, empower federal workers, and win back the trust of the American people that the government can be a force for good, because there's a lot of work to do there. So you can go onto our webpage, civilservicestrong.org. We'll put it in the chat. There's a button to get involved. And if you're interested in learning more about Democracy Works 250, what we're doing to reform the government, reimagine the way teams work, and really sort of hear from federal workers and from the American people about what they want from a functioning federal government, check out our website and send your information. We're happy to include you in the discussion.
Thanks for that, Rob. And we will put that in the chat there. And as Rob mentioned, at the partnership and at so many organizations, we're thinking about this. We have our Government for a New Era initiative. Again, both thinking about systemic changes, but really trying to, along with, Civil Service Strong and other organizations, talk to current and former federal employees, because you all have been in the system. You know what works, what doesn't. There's practitioner voice that needs to be out there. So really trying to make space for those as well. And so certainly, take a look. There's lots of ways for you all to engage should you be interested in doing that, but also come to us with questions too. I mean, the questions you all are asking, again, we all both are looking at how do we make government work better for both the federal employees in the system and the public that relies on federal services, and how do we support all of you who currently serve or used to serve in government? So these are things that we're committed to keep doing. And I know we're close at time here and want to be cognizant that people have had a long week if you're in the DC metro area with ice and snow and more ice and people out there. And so appreciate everybody sharing questions, sharing some of their experiences in the chat. We tried to answer most of those. If we didn't, please feel free. I think my colleagues Georgia and Natalie have been popping things in the chat, but they can share this SERP poll that's out there. You can also, there's contact info on our website, so please feel free to reach out to us on that. And again, this will be posted online. Please feel free to share it. I know we, Civil Service Strong, Rise Up, all have different resources on our website, so please feel free to visit those sites for more. And Rob, Mike, thank you for all you're doing with Civil Service Strong and for sharing that information. Suzanne, Jeff, thank you for the Rise Up Network and all the support you do for folks out there. And just before we leave, thank you to all of you who are online tonight joining us, and thank you for your service. It is really appreciated, and we know you all are holding down a lot right now, so just know that we're out here all supporting you. And with that, we will let people get back to the ice and snow. So thank you all, Susan. Thank you all for spending this evening with us.